Hello, hello. Good afternoon, everybody.
You should sit somewhere where you can see my stuff.
Thank you.
While I'm presenting.
Thank you to the folks at BU for hosting the conference. Thank you to the folks at BU for letting us hijack this hour of the conference. This is the University of Richmond mostly annual, we think 19th Evil Twin debate. For those of you who aren't familiar with the debate, the idea here is that, at least in theory, there's people who get along on a personal level. Yeah, in theory. But they disagree on a point of policy. And so the idea is to bring together experts to sort of debate on important IP or IP-related issue. Serious in substance, lighthearted in tone is the idea behind the debate. And in the spirit of lighthearted in tone, instead of asking each speaker to give us their bios, we ask each speaker to give us the other speaker's bio. And so I'm going to start by reading the bios for each, and then I'm going to hand it off to Bob, who's going to have 18 minutes for his side, and then Matt's going to have 18 minutes for his side. I don't know that we're going to have time for Q&A at the end, because I want everyone to be able to get to the 1 o'clock panel on time, but we'll play that by ear. So this is Bob on Matt. Suppose that you wanted someone who could really tell you all you want to know about copyright and AI. What qualifications would you want that person to have? Here's a moonshot list. Let's start by specifying that the ideal person would have written a lot on copyright, maybe a minimum of 20 law review articles, not counting symposium pieces and book reviews. That seems like a good, ridiculously exclusive beginning threshold. And this person should have gained recognition in the highest general legal circles, as evidenced by, say, having been elected to the American Law Institute. Of course, there are some people who have written a lot on copyright law, but don't know much about machine learning or artificial intelligence, so why don't we add the requirement that the person also holds an endowed chair in artificial intelligence, machine learning, and data science? We mentioned law review articles, but as long as we're putting together the ultimate background, let's stipulate that our candidate should also have published in leading scientific journals like Nature and Science. And why stop with purely academic credentials? While we are building this aspirational profile, let's add the condition that this person have testified before Congress on copyright and AI successfully and without PowerPoint. Of course, it's preposterous to think that any one real person could have all of these qualifications. How preposterous? Well, it's about as absurd as that a single person could, let's say, have grown up in the Antipodes, but with Hungarian Jewish forebears, have practiced law in 3 different countries, and have had permanent academic appointments at 3 universities and visiting appointments at 3 more, have run 15 marathons in the last 13 years. It's the most impressive of all the credentials, and have an Erdos number of less than 6. You will not be surprised to learn that at conventional confidence levels, the probability of such a person existing is indistinguishable from 0. Ladies and gentlemen, Madame and Monsieur, please welcome Professor Matthew Sagg. Here is Matt on Bob. Professor Robert Braunice, the Michael J. McKeon Professor of Intellectual Property Law at the George Washington University Law School, towers over the legal landscape like a jurisprudential colossus. From his command post as faculty co-director of the W. Bernard Center for Law and Technology, he orchestrates the future of digital law with the precision of a grandmaster moving chess pieces across the board of justice. After conquering Harvard Law School magna cum laude, Braunice clerked for not 1 but 2 future Supreme Court justices. An expert on copyright, trademark, artificial intelligence, property, constitutional law, and Icelandic legal theory, Professor Braunice is the co-author of a leading casebook on copyright law and numerous articles to boot. He founded and directs DALE, the database of AI litigation. He is a member of the project board of the Munich Intellectual Property Law Center and has served as trustee of the Copyright Society of the USA, as president of the Giles S. Rich American Inn of Court, and as the inaugural Abraham K. Hemenstein Scholar in Residence at the United States Copyright Office. Facing Professor Braunice in debate is to stand before an intellectual force of nature, a legal mind forged in the crucibles of the highest courts, tempered in the streets of Chicago, and honed to razor sharpness through decades of groundbreaking scholarship. I may have added this last line, which will make it all the more satisfying when he suffers an ignominious defeat. I will add, though, about Bob that normally you get 15 minutes and then the other guy goes, and then you get 3 minutes rebuttal. Bob's like, I don't need rebuttal. Just give me the 18 up front and we're good. So let's see if he stands up to that, starting with Bob Braunice.
Excellent. Well, thanks, Jim. And thanks to Jim Gibson and Chris Katropia and the University of Richmond for having organized this event for so many years. Many thanks also to our WIPIP host, Boston University. So our evil twin topic today is about how we should think about fair use in the context of generative AI training and deployment, and in particular, how we should think about using the concept of non-expressive use in that context. As you know, there are dozens of lawsuits in progress that may turn on this issue, and we have 2 decisions out so far, both issued last June in the Northern District of California. Here are the judges who wrote those 2 decisions, and their differences are best explained in this way. Judge Alsop picked up one quote from Matt and he took it to heart, while Judge Chabria fastened on a different quote from Matt, and he chided Judge Alsop for picking the wrong quote. So it's possible we could have an evil twin debate with Matt debating himself. By contrast, my only claim to fame is that Judge Chabria mentioned a brief I had a hand in writing, but only to reject its arguments. The thing that Judge Chabria didn't know, and that none of you know, is that I had the ultimate qualification for this debate. In 6th grade in public school in Maywood, Illinois, May of 1972, I won first prize for the science fair for what? Yes, a computer project. And what sort of computer project? So this photo is somewhat more dubious provenance than the others, but that is what I looked like at age 11. So I'm going to go with it and offer my learned perspective on how we should think about fair use in generative AI training. Okay, so as you all know, maybe the most basic quandary or tension in copyright law is this. How do we both give some exclusive rights to authors and yet preserve some user or reader freedoms? And an important part of this answer is in the limited scope of copyright protection. The most basic limitation on copyright scope is the idea-expression dichotomy, which is at least partially codified in Section 102B. We say that copyright only protects expression and not ideas or facts or useful processes. So far, so good. However, in what kind of works do you find those ideas, facts, and processes? Occasionally, but I want to say rarely, you find them in works that contain no copyrightable expression or such minimal expression that we say it merges into the idea or process. But most of the time, in fact, 99% of the time, I think, you find them in works that also contain significant expression. All those great ideas are to be found bound together with copyrightable expression. What does that mixing or interweaving do? Here I want to suggest that one of the things it's always enabled authors to do is to kind of charge an expression toll. If you want access to all those uncopyrightable ideas, facts, and processes that are in my work, you will also be getting some copyrightable expression. So you generally need an authorized copy or display or performance of a work. This expression toll has always been an absolutely fundamental feature of the copyright ecosystem, but of course it's also importantly limited in at least 3 ways. First of all, it's a front-end toll only, right? Once you've seen the ideas and facts or processes in the mix with the expression, you're free to use them as you want. This limitation addresses a concern that Judge Alsop somewhat oddly, I want to say, expressed in Bartz versus Anthropic, where he acknowledged that people may need to pay for getting their hands on a text in the first instance, but then he said it would be unthinkable to make them pay each time they later draw upon that text when writing new things in new ways. I say somewhat oddly here because I'm not sure that the Bartz plaintiffs were asking for a remedy that fits the 3rd sentence. So when I say front end, I mean to suggest the 2nd sentence, which also recognizes a normal. The expression toll is only a toll to get your hands on a work in the first place. You do not need to pay, again, each time you draw on it to write new things. Second, the toll is porous in all of the ways that copyright doctrine provides. For example, the first sale doctrine means that you don't need to buy a new copy. You could buy a used one, or you could borrow one from the library, right? However, in practice, this porousness is not so porous that no revenue gets back to the copyright owner. As we all know, and maybe sometimes even we complain about, right, the copyright industries generate substantial revenue. Third, the infringement damages are limited. If somebody learns to be an accountant by reading an infringing copy that they made of your accounting textbook, you don't get to collect even an apportioned part of their salary. Your actual damages are generally limited to the market value of your book, but they are not zero either. So this expression toll, I want to say, is recognized throughout the history of copyright law, and particularly from Baker versus Selden all the way up through Authors Guild versus Google. Remember that in Baker, the Supreme Court holds that copyright does not protect the accounting forms because they're essential to actually practicing single-page double-entry bookkeeping, and they contain little expression. But what about the introductory text that explains in English how to use the forms and more generally how to practice double-entry bookkeeping? Do we apply the merger doctrine there too as well? And the Baker Court's answer is no. right? Here's some language in Baker which discusses that. If you want to learn how to use Selden's forms from Selden, you can't just make a copy of Selden's explanatory text. That's the expression tool in action. Fast forward 134 years to Authors Guild versus Google. Of course, this case is famous for its holding that the Google Book Search Project's copying of millions of books was a fair use. But here's what Judge LaValle also says when discussing copyright in news stories. It can't be seriously argued that news reports may be freely copied and redisseminated because the facts in them are bound up with copyrightable expression. You need to pay the expression toll. Yes, once you've seen the news bulletin, you can put the facts in your own words and pass them on. But in practice, reporters and news organizations can still gain revenue as an incentive to continue reporting the news. Now, along come the generative AI developers and their lawyers and sympathetic academics, and some of them say, there's one simple circumstance that allows us to completely avoid this expression toll when training an AI model. Expression is really only expression when it's experienced by a human audience. Human beings always have aesthetic and emotional reactions to works of authorship, and indeed, we do. By contrast, computers don't have any such reactions. Our machines can't be pleased or displeased, and they aren't even seeing or hearing works, right? They're just extracting or mining ideas and facts and processes and patterns out of works. They can't be called an audience or a public. Therefore, we don't have to pay the expression toll for the machines. It's all fair use. I think that logic is dominant in Barthes and certainly present in Cadre, and some academics sometimes seem to endorse and promote that logic. Humans have to pay, machines go straight through. Of course, I don't mean to suggest that academics are themselves policemen, so let's give this handsome scholar athlete, let's give this guy a little more suitable clothing here. And I don't mean to suggest that I'm by any means the first to recognize this logic, so let me recognize that as well, right? In 2015, James Grimmelman wrote the wonderful Copyright for Literate Robots. 2 years later, in 2017, Ben Sobel followed with the amazingly prescient Artificial Intelligence's Fair Use Crisis. And there have been plenty of other contributions since then. So if we follow this logic, right, which is what I think Judge Alsup does in Barthes, are we setting up a system that is unfair to humans? And I think that depends largely on whether the computers are gaining skills and knowledge from those works that will substitute in a substantial way for the skills and knowledge that human beings normally gain from copyrighted works. For many specialized projects that we knew as text and data mining in the era of Authors Guild versus Google, HathiTrust, etc., the answer was no. But once we get to the era of ChatGPT and Gemini and Llama and Claude and Perplexity and XAI, the answer is yes. Whether we call that technology generative AI or general purpose AI, as they do in Europe, it's doing what we used to ask other human beings to do or to do ourselves. As Judge Chabria says somewhat breathlessly in Cadre, users can ask Llama to edit an email they've written, translate an excerpt from or into a foreign language, write a skit based on a hypothetical scenario, or do any other number of tasks. Well, those are, of course, things that we're completely used to human beings doing, and that we're used to human beings learning to do by, among other things, reading books and articles. If I'm interested in commissioning an essay or an illustration, I can now go either to a freelance writer or illustrator or to a generative AI service. Part of the cost structure of the human freelancer is everything they've had to pay, directly or indirectly, for the works of authorship used in their training. Under the Barthes ruling, that is not part of the cost structure of the generative AI tool. So the generative AI tool has a very basic cost advantage. True, that may be dwarfed by other cost advantages, but to put human authors at that particular cost advantage, or disadvantage, I think, is unfair. It shows up in a dramatic form right in the Barthes opinion. So according to Judge Alsup, if you gather together a huge number of pirated copies of books, and you can see that the library for this purpose has gained a lovely pirate sculpture over the front door, and you use them just to train a generative AI model, that's fine, that's fair use. But if you make copies from unauthorized sources to keep them in a library that's not restricted to AI training, but, and this has to be part of the subtext, may be read by human beings, that's not fair use. Boom, a $1.5 billion settlement after that ruling. So If there would be such an uneven playing field, how do we even it? So I'm going to reject two options and end up, of course, with mine. The first option is we mostly still allow machines to avoid the expression toll that humans must pay, but if an author can show that their work is losing market value from having been used as a training work, then the generative AI developer must pay. This I think of as Judge Chabria's favorite Matt Seg quote option. But this hardly evens the playing field because it's not a rule that we use with human authors. We do not say human authors need to pay for works that they learn from only if they themselves produce works that diminish the value of the works that inspired them. And in terms of the traditional factors in the fair use inquiry, I think this option wrongly concludes that generative AI models are making a really transformative use of the training works. So it counts factor one as heavily favorable for fair use, and then as a result concludes that the training work owners must have show an effect on the value of their particular work under factor 4 to defeat a fair use claim. It turns out, of course it's controversial, but that the use of most works to train generative AI models is not a particularly transformative use of those works. So when human beings read the explanatory text from Selden's condensed ledger, they do so to learn something about how to perform single-page double-entry bookkeeping and to be able to talk about that kind of bookkeeping. That's the ordinary purpose of that explanatory text, and the Baker versus Selden court says you have to pay the expression toll there. And of course, you're free to talk or write about double-entry bookkeeping in your own words afterward. So now a generative AI model digests Selden condensed ledger and other books, and it's now able to write about single-page double-entry bookkeeping in its own words. Are we using the Selden text for a transformative purpose, a completely different than ordinary purpose? I think no, we are not. Let's go one level deeper with learning and transformative purpose. If we use a text like Selden's explanatory text just to learn English, to gain the ability to interpret English sentences, to write English sentences, don't we have a transformative purpose there? Because we could say Selden wrote the text to teach people about single-page double-entry bookkeeping, not to teach people English. And here I want to make a very important point about human learning and then an important point about purpose. So first, human learning. Just as we human beings can't shut down our aesthetic reactions, nor can we shut down our learning. We are always on as learners, always changing, never merely passive and unchanging audience. When we experience a work, it changes us. Moreover, although we may naturally think of learning as a conscious experience, most of our learning is unconscious, implicit learning. So when a generative AI developer says, our models just learn statistical patterns in text, guess what? So do human beings. Second purpose. If the ordinary effect of some work is that those for whom it's produced, human beings, update their understandings of language from that work, then I think we have to count that effect as one of the imputed purposes of that work. We certainly can't say that the use of the work to do for AI models what it ordinarily does for human beings is a transformative purpose. If the use is not particularly transformative, then the need to show particularized market effect is diminished. And I think that's important. Judge Chabria states that he thinks that in most cases, generative AI will undermine markets for training works. But then actually he gives examples that I think make it seem quite difficult to show particularized harm, and I think it probably would be. However, I don't think that there should be any need to make such a showing because that's not something we've ever required in the case of a human user. So what's the second option to mitigate the unfairness of the human-machine divide? When I think of this option, I think first of another distinguished scholar-athlete who's not in this room, who's seen here directing somewhat altered traffic flows, right? The option here is to let some human beings pass through the toll-free lane as well. If you demonstrate that your purpose in copying works of authorship is to extract unprotected elements, ideas, facts, and processes, then the fact that you're also copying and being exposed to copyright-protected expression should be excused. So if you carry a shovel to show that you're just extracting things, and you wear dark glasses to show you're not interested in visual delights, then you get treated like the computers, right? And in a way, and by the way, Mark Lemmy, sitting right here in front of me, and Brian Casey suggested, I think, something similar in fair learning, although they were writing in the just pre-generative AI era. So although I think this is an interesting approach, I also have some difficulties with it, right? First, although it reduces the unfairness, it doesn't eliminate it. The computers escape copyright altogether, but if the human beings get something more than incidental from the expression, they don't get to pass through with the computers. Second, I think this test is hard to administer and ultimately arbitrary. Remember that a basic feature of our human nature is that we're always both enjoying and learning. We're doubly always on. And our judgment of what we learned and what we enjoy may change over time. In retrospect, some TV program that we thought we were just enjoying may turn out to have been a great inspiration. And a poem that we were just assigned in school to learn from may become one of our favorite works of literature. So to try to sort between learning activities and enjoyment activities is denying one side or the other of every human experience. So where does that leave us? Well, so here's where it leaves me. I think we could recognize that in that context, the concept of expression is not primarily about enjoyment of works as aesthetic objects, but it's about this narrow but important front-end, porous, limited damages toll that's an important part of the copyright ecosystem. We may sometimes talk about the personality of the author or the ears of the listener, but it's clear that copyright law allows authors to charge an expression toll even when readers are overwhelmingly interested in the ideas or facts in a work and not the expression. So as a matter of fair use, when computers are gaining skills and knowledge from copyrighted works that are substituting for human skills and knowledge, we should generally allow authors to charge an expression toll when works are copied in full and fed to computers, just as we always have when they're copied for human use. And both computer and human uses can be fair uses in appropriate, narrower circumstances. Does that mean that I don't appreciate what generative AI can do for me and for what it can do for society? No, of course I appreciate that in many ways. Here's a recent photo of me in a figure drawing class. It turns out that my drawing skills leave something to be desired. And it also turns out that using a generative AI tool to cook up illustrations is a lot cheaper than using a human illustrator. But I will also say this. I did most of the work on these illustrations with Adobe Firefly, which is trained on licensed and public domain works. So just as Judge Chabria expressed in Kadri a healthy skepticism of the argument that generative AI developers can't possibly afford to pay for the works that they use to train their models, I too am skeptical that tech companies that have spent an estimated $300 billion in 2025 on chips and electricity and expert labor can't possibly arrange to pay authors for training works. Of course, there are other important, policy questions like market concentration and bias and international competitiveness. We can discuss those in Q&A, but for now, I thank you, and I will turn the floor over to my somehow inexplicably much younger twin, and I'll leave you to decide which is the evil one. Thank you. Okay, I'm just going to put this back on.
You could just leave that on.
I'll leave that on the whole time. Yeah. Oh, should I sit here or down?
I mean, as do I. Ladies and gentlemen, it's an honor and a pleasure to stand before you here today. I have to thank my worthy opponent and evil/good twin, Professor Bob Brownice, for making me thinner and younger in most of those illustrations. Who could ask for more? I apologize for not having slides, but I have an outrageous Australian accent, which I will be putting on for the entire performance. I wasn't sure if this debate was going to be a debate about doctrine or a debate about policy. I think it ends up being a debate about policy, because to have a debate about doctrine, you need to have a theory about what copyright is for, and that theory needs to make sense of the cases. And with the greatest respect, I don't think Bob has a theory about what copyright is for, other than the policy of creating a good economic infrastructure to support creativity and human culture and human expression, right? I start this a little differently because I came up with this theory in 2008 before I knew what machine learning was, right? My theory of non-expressive use basically looks at copyright law and says, well, sole and despotic dominion, as Blackstone talked about, it really isn't a very good description for what copyright law is trying to do. What is copyright trying to do? And so I looked at various doctrines, the idea-expression distinction, the fact that we assess infringement by reference to what would an ordinary observer think if they compared the protectable expression, and various other doctrines, is that, you know, it's really the communication of original expression to a new audience. That is what copyright tries to regulate. So what copyright cares about is expressive substitution. Fair use is not an anathema to copyright. It's not something designed to undermine copyright from within. Fair use complements copyright because fair use is primarily about expressive substitution. We're fine with transformative works such as parodies because even though they borrow some expression, the context in which they use them is so different, we just don't think substitution for the original expression is very likely. When you apply that to computational uses, to text mining and now to machine learning and generative AI, that leads to a very clear implication. If a use is genuinely non-expressive, it genuinely doesn't communicate the original author's expression to any new audience, right? I'm not going to say that that is always the end of the conversation, but I think that is quintessentially transformative under factor one, and then we need to talk about factor four. Bob tells us that we're treating humans and computers differently, and that this is true. This is true, right? If computers read the same way we read, we wouldn't need the fair use doctrine, right? The reason we're having a conversation about the fair use doctrine is because computers do read differently to how we do. But that doesn't answer the question, it just frames and states the question, right? I think the fundamental misconception behind Bob's just confounding rejection of my theories, and the Copyright Office's confounding rejection of my theories, and some of you in this room, your confounding rejection of my theories, the fundamental misconception is that naming things is hard, right? Non-expressive use for some people triggers like the wrong set of associations. They're like, well, I think the output is expressive in a First Amendment sense. And I apologize for that confusion. It's the best term I could come up with. It tracks the idea expression distinction. But I think Bob is confused between benefiting from the ability to process expression, which AI models clearly do, right? And that's a clear difference between HathiTrust and Google Books, where the computational process is actually indifferent to the quality of the expression. It's all about producing metadata on the other end. AI models are not indifferent to the quality of the expression. You show a model some high quality expression, that will help it learn what high quality expression looks like. That's valuable. But benefiting from the expression is not the same thing as communicating that original expression to a new audience. I think what copyright cares about is what's communicated to a new audience, whether that is substantially similar. And I just don't think that copyright law thinks of all benefits as stealing. This brings me to, I think, where the debate is joined. I'm glad Mark is here because he's like a sort of third participant in this debate almost, with fair learning. Bob says, no, we have to pay the expression toll. And I actually agree that learning is not like a get out of jail free card. that learning is not a blanket justification for all copying. And I think maybe I sort of disagree with Mark a little bit here, although perhaps I'm overreading his paper. But Bob goes way too far. What a shock. A legal academic positioning himself as the reasonable middle ground. But Bob treats learning as sort of prima facie infringing, as that's the original sin for which we need to atone by passing through these checkpoints and these access points. He treats that as infringing in principle and sort of just merely tolerated in practice. But I don't think that's right. I think Bob is confusing paying for learning, which we do not do, with paying for access, which we do all the time. And it's true. Sometimes humans pay for access to works, sometimes we do not. Sometimes robots will have to pay for access to works, sometimes they will not. I don't think that it's fair use for an AI company to scrape the internet for its training data in a way that ignores robot.txt exclusion headers, that circumvents paywalls, et cetera, et cetera. I think, and this is, I think, regrettable in some ways, one of the reactions we're seeing to AI is an increasing use of checkpoints on the internet, right? But that's how the money moves around the system, right? The Wall Street Journal puts a checkpoint up and then OpenAI bribes them to take it down just for them. That's a reasonable system, right? But the defaults matter because you cannot license all of the digital ephemera on the internet. You cannot license 30 trillion tokens of training data just because you can license from the Wall Street Journal or the publisher of Vanity Fair, et cetera, et cetera. I don't disagree that there may be some small concentrated pockets of expression that model makers will find worth paying for, and that OpenAI can go to a big media company and do a deal for their entire portfolio of training data, right? But a handful of cherries doesn't make a sundae. We need to train large models on the whole sundae. And so yes, this isn't necessarily true of every type of generative model, right? You can make Adobe Firefly trained purely on licensed data. By the way, it's licensed in the sense that Adobe had pre-existing rights to all of this stock footage. It's not like those photographers knew that their works were going to be used in training. It's not like those photographers are receiving any meaningful compensation for that, right? But it is true, there are a handful of people who have access to huge portfolios of images, and you don't need internet scale to train certain models, but you do need them to train the most advanced models. You do need them to train the LLMs. And it would be weird if we had a copyright principle that basically said the biggest, hugest, most commercial models train for free because nothing else is reasonably practical, but anything smaller has to pay, right? That to me seems incoherent, and ultimately I don't buy it. Bob sees this as a contest between humans and machines. And, you know, on Judgment Day, when it's a battle between humans and machines, we should all be on Team Human. I think? Is that controversial?
Yes.
But this framing is wrong, right? This is not humans versus machines, right? Bob is not standing on the high moral ground of being on Team Human. This is humans versus humans. There are humans on both sides. There are human users of generative AI. There are human creators of generative AI. And there are human authors who would like to have a copyright system that was more beneficial to them than the current one seems to be. But it's not a choice between humans versus machines, right? We're not doing this for the benefit of the machines. These machines are our instruments, and they ultimately serve human values. So the question is not, which side are you on, humans versus machines? The question is, why do some humans have the right to tell other humans what to do? And I say, you know, copyright law allows that up to a certain point, but we should go back to copyright law first principles to figure that out. I think when Bob sees this as a contest between humans and machines, he's worried that we can't compete. He's worried that the robots are going to be faster, better, more capable, more prolific, and that human authorship is just going to be deluged and diluted out of cultural and economic relevance. I have 5 observations about this. And don't worry, Jim, this is where I'm finishing up. My first observation is, as a doctrinal matter, this doesn't help. This doesn't distinguish Google Books and HathiTrust, right? I have a couple of friends who use the HathiTrust archive to read 170 years of English literature, 200,000 books, to train a machine learning model to analyze gender and the associations of how many words on the page were associated with particular characters, to basically chart how female representation in fiction evolved over the last 170 years. Like, they transcended human abilities. Most English PhDs read a dozen books and talk about them incessantly. These guys effectively read 200,000, right? So we've seen this before. I don't think that's a distinction. But more important are my 4 remaining points. Bob is worried that humans can't compete, right? I think this harm is entirely conjectural. I think the harm is conjectural. I think it misunderstands or discounts the limits of non-expressive use. It misunderstands how there will still be requirements to pay for creative work, even in a system that recognizes non-expressive use. I also think that Bob's argument, for it to be correct, then the harms have to outweigh the benefits. And that's just conjecture twice over. Like, we have to know what the harms and the benefits will be in order to compare them. But more profoundly, believe it or not, I'm already at point number 4, these harms are collective and not individual. And this is the real conceptual problem with the market dilution thesis, is that it posits, without really any evidence, but it posits based on intuition, that copying these specific works to which we attach private property rights will harm, well, all of us collectively. And our legal system is not very good at addressing collective harms, I will grant you, but it seems like quite a twist to take copyright, which gives individual rights to authors, and let them assert collective rights. Let them assert the right to speak on the collective. And this is fundamentally the problem with this market dilution theory. It's not that there really isn't much evidence. It's not that the theory's kind of weak, right? It's that ultimately it puts some authors in a position to speak for all of us, and no one elected them. No one appointed them, right? I'm not suggesting Congress in its infinite wisdom could not reconsider the copyright bargain that was struck in the 1976 Act and elaborated through case law, right? They'd probably do it very badly, I admit, but that would at least be through a legitimate, democratic, participatory process. So my final point is just that when you are using individual rights to assert a collective harm, you are gazumping a democratic process. You need to have a mechanism of delegation, a mechanism of accountability. The closest thing we have to that is the class action process. And that doesn't really work that well, right? I think this idea of market dilution is unsound as a matter of doctrine. It's unsound as a matter of policy, and it's inherently undemocratic. I don't think that we need to choose between humans and machines. I think that copyright in its current form creates space for all of us. And by all of us, I mean those humans who aren't in favor of the newest wave of machines, and those humans who think that their potential is something that's going to contribute a lot to our society. We've seen this story before. Almost every new technology is confronted with a wave of anxiety and opposition, right? I'm not saying that just because it's worked out every time in the past, that it will definitely work out this time. Maybe this time is genuinely different. Maybe we are like 3 cycles of technology away from the Terminator films. But I don't think so. I think generally history tells us that we will figure this out, that the copyright system will figure it out, but not by making an incomplete policy calculation its lodestar, but by going back to first principles, which is the idea-expression distinction and the fundamental realization that copyright is about the communication of original expression. Thank you.
Well, I, for one, welcome our new AI overlords. I'm aware that the next panel starts in about 7 minutes, so I don't actually think we have time for Q&A. So if you can just join me in thanking Bob and Matt one more time. Oh, and we have next year's debate topic, which is, are you human side or robot side? I think. Yeah.